Judith DeBerry for the Commission for Lawyer Discipline. May it please the Board. This is a reciprocal disciplinary action pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on the respondent, Ms. Garrett's professional misconduct and suspension in Minnesota. The petition for reciprocal discipline was filed with the Board on August the 25th, 2015, and the first amended petition was filed on November the 24th, 2015. The order to show cause on the first amended petition for reciprocal discipline was issued by the Board on November 30th, 2015, requiring the respondent to show cause within 30 days while reciprocal discipline should not be imposed in Texas. The respondent signed a waiver of citation on December the 8th, 2015, acknowledging receipt of the first amended petition for reciprocal discipline and the notice of hearing. The waiver was filed with the Board on December the 10th, and respondent filed an answer on January the 5th, 2016. On November the 5th, 2014, findings of facts and conclusions of law and a recommendation for discipline was filed with the Supreme Court in the state of Minnesota in the matter styled In re petition for disciplinary action against Mpatanishi Syanaloli Tayari Garrett, a Minnesota attorney, registration number 34207 file number A14-0995. And on July 1st, 2015, an opinion was filed in the Supreme Court of the state of Minnesota in the same manner that states, respondent is indefinitely suspended from the practice of law and shall be ineligible to apply for reinstatement for a minimum of 120 days from the effective date of the suspension. The referee in the disciplinary proceedings concluded the respondent violated the following Minnesota rules of professional conduct. Rule 3.4C, Rule 8.4B, C, and D. By willfully disobeying a court mandate, by making false or misleading statements to a tribunal, and by being convicted of criminal contempt for willfully disobeying a court mandate. At this time, I have four exhibits I'd like to introduce. Exhibit 1 is a certified copy of the findings of facts and conclusions of law and the recommendation for discipline filed in the Supreme Court of the state of Minnesota. Exhibit 2 is a certified copy of the opinion of the Supreme Court of the state of Minnesota in the same matter. Exhibit 3 is a certified copy of the order denying the petition for rehearing in the Minnesota disciplinary matter. Exhibit 4 is the original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated January 8th, 2016, which indicates that the respondent is licensed and authorized to practice law in the state of Texas. May I approach?
Have you shown me?
I have a copy.
You have any objection?
No, Your Honor.
Okay.
At this time,
They're admitted.
we would offer these.
The exhibits are admitted.
Thank you. As reciprocal discipline, the Commission respectfully requests that a 120-day suspension of Ms. Garrett's license be imposed as reciprocal discipline. And I believe
Is the CDC asking for 120 days? Because I don't know how the Minnesota provision, it says 120 days, at which point she can ask for reinstatement.
correct. And to my knowledge, she has not applied for reinstatement at this time. We do not have indefinite suspensions in Texas, which is the reason we're asking for the 120 days. It's a definite period. And I believe she's raised some affirmative defenses that I'll let her address, and then I'll respond to those.
Thank you.
One of the main reasons I'm asking that the state not impose reciprocal discipline is because the State Bar of Minnesota and Minnesota's Board of Professional Responsibility for Lawyers does not have the same checks and balances as this board for the State Bar of Texas. There's no statute of limitations, there's no appellate process, there's no option for jury trial, and there's no significant screening process for complaints as we have here. When such processes are not in place, what can happen is what happened to me. Those with power, whether it's politically connected prosecutors or judges or large firm lawyers, are inoculated from discipline, while others, solo practitioners such as myself, are criminalized, stripped of their licenses, and face roadblocks designed to break them financially. The affirmative defenses that I present to the board are fourfold. First, there was no actual proof to establish misconduct, and certainly not by preponderance of the evidence. And as you'll see in Exhibit A that I submitted with my answer and affirmative defenses, the entire transcript of the hearing that occurred. If you review that transcript, you'll see that the board did not actually present any evidence of misconduct.
Let me ask you, just for clarity, were you aware that it was perceived that you had been hospitalized and were impaired against showing up at a time when you actually were in Paris at your brother's wedding? Were you aware that that was the perception given to the court by your communications?
No, because that was not the perception given to the court. As soon as I got out of the hospital, I immediately contacted the court and told them that I was out of the hospital.
And that you could not come to court?
That I could not
That it
do
was
a
too
trial.
soon? That it was too soon?
Yes.
And that's why I asked, don't you think there was a perception to the court that your impairment prevented your coming rather than your presence in Paris at your brother's wedding?
My impairment certainly prevented me from doing a felony trial for a woman facing significant time in court. It did not prevent me from sleeping on an airplane.
Right. And then where in the record, in the two transcripts that you attached or elsewhere, does it show that you furnished to the judge the information about the medical condition that you had been directed to furnish?
Yes. In fact, the judge ordered me to furnish proof that I was in the hospital by 10 a.m. on a Wednesday, and I did so. I furnished that to the court and to the judge. During the transcript of the hearings, the telephonic hearings, the judge said, well, that's just not enough. I repeatedly requested what else would the judge like other than the documents that I got from the hospital, and that was never stated nor clarified. Again, there was no actual proof of misconduct, or certainly not by preponderance of the evidence. The complaint that was levied against me was not by my client. It was by the prosecutor. It was a very contentious case, and the prosecutor filed that complaint as well as pursued the criminal charges against me, as well as testified at the criminal hearing. And at no point was my client even ever asked to testify at my board hearing. At no point was even the judge asked to come and testify. It was purely pursued and relied on by the prosecutor. And interestingly enough, that prosecutor himself, when asked about whether or not I misguided the court, the prosecutor stated, and I believe the quote was, it was unclear as to whether or not I did, and certainly that's not proof or evidence. Second affirmative defense that I present to the board is that it would be a continuance of a grave injustice to impose the discipline identical to that done in Minnesota. You'll see in Exhibit C, I listed a number of cases where attorneys were convicted of misdemeanors or gross misdemeanors or faced charges similar to the ones that I faced, and none of them, not one, received more than 30 days suspension. There was one particular case that the court, that the Supreme Court of Minnesota relied on, where the charges were eerily similar to my charges. There were a few more charges that she actually had that I was not ultimately charged with. It was the Henry Michael case, and she received 30 days. And when that was brought up to the court said, well, the difference is that she wasn't criminally convicted. Well, that's not a difference, because what happened was we were charged with the exact same, we were in the exact same situation and charged with contempt of court. The only difference is the prosecutor actually charged me with the crime. The actual underlying facts are not very different. So the fact that I was actually charged with the crime should not be an impetus to give me even more punishment than in that case. There was another case just in 2011, Henry Hoffman, where the gentleman was convicted of a gross misdemeanor. And at that point, the Minnesota Supreme Court said, well, he suffered enough. He went through the criminal justice system, he has a criminal record, and he paid enough by way of a fine that we're not going to impose any discipline on him. And so he was not disciplined at all. Third, with respect to my affirmative defenses, if any discipline is to be levied, the misconduct established would warrant substantially less discipline in Texas, and even in Minnesota, as I just stated, it would warrant substantially less disciplined. And again, that's detailed in Exhibit C with respect to the much less discipline that it would even warrant in the state of Minnesota. And four, there are certain of the allegations, specifically the criminal misdemeanor and the charge of conduct prejudicial to the administration of justice, which, as far as I can tell, does not constitute professional misconduct in Texas. With respect to the misdemeanor conviction, my understanding is that unless it's a felony or unless it's a misdemeanor involving theft or involving moral turpitude, the state of Texas does not automatically impose discipline for that, and neither of those was the case here.
I want to go back to my first question to you. There was a finding, whether accurate or not, there was a finding that you failed to furnish any of the documentation that the judge directed you to furnish. And my question is, where in the record that you have brought in this case does it show that you unequivocally, without any contradiction in the evidence, furnished that?
If you review Exhibit B, which is the brief that my lawyer submitted.
That's a brief, right?
Yes, we actually reference different portions of the underlying record in that case, and we address that that very same matter that you're inquiring about here.
Show me where that is. That's, in other words, you're saying that the finding by the Minnesota court is wrong and without any evidentiary basis.
Certainly not preponderance of the evidence. There certainly is not a preponderance of the evidence.
So help me find where you show conclusively that all of the information asked for by the judge was furnished.
If you look at page 21,
Thank you.
it discusses the district court proceedings, but there's another more specific issue, I believe, a more specific identification of the documents.
Page 21 says you showed some witnesses and so on. I'm not yet finding any, I'm not yet finding the record contradicting the Minnesota court's finding of fact.
Is there a cite to the transcript?
I believe that there's actually a cite to one of the pieces of the documentary evidence that was brought in, not the transcript for the hearing, but the transcript for the actual hearing with the judge in 2011. So it should be a cite to that.
Any other questions?
Oh, I'm sorry. Okay, so if you look at page 19,
Thanks.
and then if you look at the second paragraph, It says the referee's findings were clearly erroneous in concluding Garrett's statement concerning a follow-up medical appointment that week. The evidence does not support this finding. The fact of the follow-up appointment is proven from the hospital discharge records admitted into evidence. So the hospital discharge records are the records that were requested, and those were provided to the court.
That doesn't show that they were provided, the discharge records were provided in the evidentiary hearing. What is in this record to show that by 9 a.m. as ordered, information was put in the court's hands back in early May?
Right, so it references Exhibit 16, and Exhibit 16 was the actual transcript in the underlying case. So it shows that the discharge records were not submitted in this court, but actually in the underlying court in 2011. And we can get you a list of those exhibits.
Have you reapplied in Minnesota?
I have not. It's very expensive to reapply. They've fined me over $1,000. I don't know exactly how much it was, but no, I have not applied.
Do you understand that, at least the way I read the Minnesota order, it's 120 days and then you get to reapply, which could be indefinite, whereas Mr. Berry is saying the CDC is only asking for a flat 120 days. Do you understand the difference between the two?
Yes, Mr.
So
Taylor.
it seems to me that the penalty that they're asked for is significantly less than in Minnesota. Would you agree with that?
It is less, yes.
Thank you.
And it is also certain as opposed to indefinite.
Yes, the 120 days has passed. I believe the order came down last July. I just have chosen not to reapply.
And as long as you don't reapply, that suspension is in order, correct?
That is correct.
Thank you. Any other questions in the panel? Thank you very much.
Thank you.
Board, I'd like to respond to some of Ms. Garrett's arguments. I don't believe there was an infirmity of proof. There's actually quite a bit of evidence in the record and testimony. It's one of the things she was asked to provide that she never provided on the 3rd was an affidavit from the medical facility, from the doctor, which included her prognosis and when she would be able to continue. And I think it's important to note that the email that she sent, and I'm going to read it, was very specific and clearly intended to mislead. I have just been released from the hospital and will definitely not be able to attend a scheduled hearing this Thursday, May 5th, too soon. Taken together under the circumstances, that's clearly misleading. And comment 2 to Rule 3.03 indicates that in many circumstances, an omission is the equivalent of an affirmative representation, as it was in this case.
When did she fly to Paris?
She flew on the 4th. So she actually flew through Minneapolis on the 4th, which is where the court was being held on the 2nd and 3rd and on the 5th. So she was actually in Minneapolis in the courtroom, and they had videotape from the airport showing.
What about her argument that the procedures in Texas are different than Minnesota? That is, that she doesn't get an appeal. Do you consider the referee finding and then the appeal from there to be such an appeal?
I think that's a two-step process. The process in many states is different. I think she also had the ability, and she did ask for a rehearing, which in many states is the equivalent of an appeal, and that was denied. And specifically in that they found some of her pleadings were frivolous.
But she didn't have the opportunity to appeal to an appellate body such as we are. Is that correct? Because their disciplinary proceeding, and as in many states, the Supreme Court is the one that makes that final decision.
Has the due process issue been raised as to the Minnesota system and found to be, that it meets the due process standards, or is this just no law on that?
I have not seen any authority that says that it doesn't meet the due process standard. She did not raise that in her pleadings, so I really didn't look carefully into that
Fair enough.
issue. That was not one of the things she raised until today. As far as a grave injustice, her argument doesn't even touch on what it is in Texas. It's basically that she, for some reason, feels she was discriminated against in the proceedings in Minnesota, and then she goes into the sanction that was imposed. And I would refer the board to look at the elements and the aggravating factors that the referee or their hearing officer listed that he considered when imposing sanctions. And many of those are the same as we have in our Rule 2.18 and 3.10, which are the factors that evidentiary panels and courts consider when imposing sanctions. And those included the nature of the misconduct, and he specifically found that her actions were intentional. Her conduct during the proceedings, including making further misrepresentation during the disciplinary proceedings. The profit to the lawyer, in this case, her self-serving motive to go to Paris. The loss or damage to her client, that's speculative, but obviously to the client, to the court, the administration of justice was delayed because they couldn't move forward with the trial.
Ms. DeBerry, the standard is we have to honor the Minnesota determination with a few exceptions. So this is an exception. What is the burden of proof, and who is it on with respect to grave injustice?
It's her burden of proof to prove the affirmative defenses, and in any of the defenses that she raised, and I don't think she's met that burden. Another thing the court found was that she failed to recognize the wrongfulness of her conduct, and there was no showing that future clients, that this misconduct wouldn't occur in the future. Significantly, the court found no mitigating factors in the disciplinary proceedings against her. I've looked at similar cases in Texas, and while I can't find one that's exact, I've seen a range in the published cases from, I think the low end was 18 months, partially probated with 3 months active, all the way up to disbarment. Now, the underlying facts in some of those and that was just an 8.04A3 rule violation for dishonesty, fraud, deceit, were different in a lot of those, which account for the range of sanctions. Her argument that the misconduct is not, or the rules are not the same, is misplaced, because all the Texas rules require for reciprocal discipline is that her conduct in Minnesota would constitute misconduct here. And it absolutely would. 3 of the 4 rules are, if not identical, substantially similar to the Minnesota rules. She makes the argument that the 8.04, our 8.04A2 requires that a misdemeanor doesn't qualify. However, if you read that provision carefully, it's a disjunctive provision, and it's a serious crime or any other crime that reflects adversely on the attorney's honesty, truthfulness, or fitness to practice law. And the fact that her criminal contempt charge, although it is a misdemeanor, was directly related to her practice of law, I think does reflect this on her ability, or her truthfulness and honesty and fitness to practice law. The other rule, the final rule, is significantly different. I don't think we need to reach the argument on interfering with the administration of justice versus obstruction of justice, because we've already established that 3 of the rules are essentially the same, and it does constitute misconduct in Texas.
Any questions? Anybody? Thank you very much.
Thank you very much.
We'll take